Hello, everyone, and welcome to today's webcast, Limiting Liability and Terminations. This webcast is a series of webcasts on a monthly basis of current HR topics with specific recommendations that you can implement at your workplace. As always, today's webcast is brought to you by our PEO divisions, including Employer Solutions Group, Professional Staff Management, and Century 2. My name's Kim Troop, and it's my pleasure today to serve as your moderator. Before we get started, I'd like to cover a couple of items. At the conclusion of today's webcast, all participants will be emailed a copy of today's presentation. During the webcast, all participants will be muted, but you're encouraged to submit questions by typing those in the panel on your screen, and we will attempt to address as many of those as we can at the end of today's webinar. So moving along to our session, I'd like to introduce Mark Trimble, who will present our first part of the topic. Mark?
Thanks, Sharon, or Kim. Well, welcome everybody. Good afternoon. The presentation today that we're going to be sharing with you is the topic is understanding potential liability associated with terminated employees. I'm going to take the first half of this presentation and I'm going to dive into a few different areas as it relates to the laws that protect employees, which means that employers really need to understand those laws so that they can act appropriately. So what I'm going to do is I'm going to go through those various things that I think employers need to be aware of on the front end, and then David Kyle in the second half of the presentation is going to go through some best practices and some give some practical advice as far as the actual termination meeting, what to do, what not to do, how to handle that situation. So hopefully by the end of the webinar here, you're going to be able to walk away with some added knowledge to help you understand a little bit better how to respond to terminations. The intent of this presentation is not to scare anybody, because anytime we're thinking of terminating employees, that can become fearful with employers because there are so many different laws that protect employees. But I think as we go through this, you'll see that as an employer, you have the ability to, if you understand the laws, you can fairly safely navigate through the things that you should and shouldn't do. So I'm going to start out here with, Kim, it actually looks like I don't have control. Can you give me control so I can move the slides? Hello?
Mark, go ahead and just click onto the screen itself and see if then you can use your controls from the bottom.
No, nothing happening yet.
All right. Right. If you moved your mouse onto the screen.
Okay, let's try that again. No.
All right, now try.
Okay. All right, from an overview standpoint, we're going to go through 4 different main areas. The first area is what we refer to as protected employment classes. The next section is at-will employment. Then we're going to talk briefly about terminations that are for performance-related reasons. And then at the end, we're going to talk briefly about terminations that are related to a layoff or position elimination and understanding the difference between those two. Protected employment categories. So the question arises, what is a protected class? Protected class is a characteristic of a person which cannot be discriminated against by law. The EEOC, or Equal Employment Opportunity Commission, is tasked with enforcing the laws that protect employees against the following types of discrimination. And I'm just going to touch on each one of these briefly here. Age, disability, national origin, race/color, religious beliefs, sexual harassment, sexual orientation, and pregnancy. And what I'd like to do is go through each one of these briefly in the following slides just to talk about each one and what it means from an employer standpoint as far as how employees are protected. First one is age discrimination. Age discrimination is treating an employer applicant that is 40 or older less favorably. And I want to emphasize here that with regards to any of these discrimination categories, it applies to the employee or an applicant. And I also want to point out that there are company size thresholds, meaning the size of the company comes into play as it relates to the various discrimination laws. With respect to age discrimination, that threshold is 20 employees or more. And then the next one is disability discrimination. So this is where an employer treats an employee or applicant unfavorably because he or she has a disability or a perceived disability. And employees are protected under the Americans with Disability Act or the ADA. And this law applies to employers with 15 or more employees. With respect to disability discrimination, the key here, one of the keys rather, is employers need to be aware of the fact that they may need to provide what's called a reasonable accommodation for an employee that has a disability. And essentially what a reasonable accommodation is accommodating an employee in whatever way is deemed appropriate and reasonable that will allow the employee to perform the essential functions of the job. Another thing to point out here as it relates to the ADA is just as of not that long ago, 2008, the American Disability Act, Americans with Disability Act, was expanded. Amendments were added. So right now there is a lot more things that are covered as far as what's considered a medical condition under the Americans with Disability Act than previously. The next discrimination category is national origin discrimination. And this is treating an employer or applicant unfavorably because they are or appear to be from a particular part of the country. And in gray there, I've just indicated the act and what laws are specific to it. And many of these you'll see are Title VII of the Civil Rights Act of 1964, which was a landmark legislation which included a number of these things that we're talking about right now. Next category is race or color. And this is treating an employer or applicant unfavorably because he or she is of a certain race or because of personal characteristics that are particular to a race. Hair texture, skin color, such as that. Religious beliefs is treating an employer or applicant unfavorably because of his or her religious beliefs. And it's important here to understand this is not just discrimination against someone who is of a well-known religion. This protection also applies to people who have sincerely held religious, ethical, or moral beliefs. People in that category as well cannot be discriminated against. Next one is sexual harassment, which I'm sure most employers out there are aware of because it's so prevalent. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. This again is protected under the Civil Rights Act of 1964. And I would also want to point out that with regard to the threshold for this one is 15 employees. However, as it relates to these laws, I'm citing the federal legislation. In many states, there are laws that are more favorable for the employee where the employer actually, the size of the employer, the threshold is actually lower than what the federal laws are. So be sure to check and verify first before looking at a situation and saying, well, I only have 10 employees, so I don't have to worry about that. For example, in Arizona, sexual harassment applies to if you just have one employee. So that's something to be aware of as it relates to any state laws which may overlay the federal laws, and we always defer to that law that is more protective for the employee. Sex-based discrimination. This is different than sexual harassment. What this is discriminating based upon the gender of an individual. So an example might be an employer that felt like they just did not want to hire a male for a position because from a general standpoint, they're more comfortable with females in that role. There are, in fact, positions that can be tied to just male or female. However, those have to have bona fide occupational qualifications attached to them. You can't just make that determination that this is a male position, this is a female position. And the last one that we're going to talk about as far as the protected categories is pregnancy discrimination. And this is treating a woman unfavorably because of pregnancy. So what that means, I jumped ahead here real quick, but essentially what that means, we're talking about pregnancy discrimination, is you cannot discriminate because a woman is pregnant. You have to treat her the way you treat any other employee. Some final thoughts on discrimination. First, before terminating any employee, first consider whether they might be protected under any of the EEOC discrimination categories we just went through. Very absolutely, I think, for employers to understand and to give them some peace of mind is that employees still must perform their job. Protected classes do not absolve any employee of having to perform the essential functions of the job. They still have to be able to do the job that they were hired to do. They can't hide behind these protected categories. However, with that said, it's important for an employer that is dealing with an employee in a protected category, it's important to be able to have documentation and a paper trail to show the reasons, the rationale behind a termination when you're dealing with an employee who falls into a protected category. And ideally, the documentation should clearly demonstrate that two things. First, that the employee was made aware of the performance deficiency, and two, they were given the opportunity to improve. So next, I wanted to move into a related but different category, and that is retaliation claims. Retaliation-related discharge is separate from anti-discrimination laws in that a number of federal laws make it unlawful for an employer to fire an employee for merely asserting their rights under the laws. Well, we're going to talk about what that means here in just a minute, but the retaliation claims are on the rise. According to the EEOC, nearly 43% of all private sector claims filed in 2014 included retaliation claims. And when you think of the number of EEOC discrimination categories we just went through, it's staggering, I think, to think that so many claims are tied to retaliation, almost half. And employers can retaliate in a number of different ways. And in many cases, they may not even realize that they are retaliating against an employee. Further complicating this, just as of this year, 2016, the EEOC issued newly proposed guidance related to retaliation. And the EEOC took a very aggressive stance against retaliation, and moving forward, employers need to be particularly aware of retaliation in the workforce and what exactly it is and how the EEOC looks at retaliation and what is considered retaliation. Let's look at a couple areas right here that are pretty common in which employers may stumble and retaliate, and in some cases not even be aware. The Fair Labor Standards Act is the federal wage and hour law. And the Fair Labor Standards Act protects employees who start proceedings or take actions in an attempt to have the law enforced. So this would include things like if there were overtime violations, minimum wage violations, potential violations as it relates to an exempt or a non-exempt employee, also violations related to commissioned employees. Any employee who files a complaint or complains against their employer as it relates to any of these items that are covered under the Fair Labor Standards Act would be retaliating against an employee. So the takeaway here is to be cautious of terminating an employee just because they have filed a wage and hour claim against your company. Another broad category is the Occupational Safety and Health Act, which is OSHA. Also be very careful of terminating an employee just because they filed a complaint with OSHA regarding workplace conditions. So with regards to retaliation, employers may not retaliate against employees for any of the following. Here's a few examples. We touched on the wage and hour laws. An employee that has filed a wage dispute with a state or federal agency, employers cannot retaliate against an employee for doing that. An employee that has been injured in a work-related injury and filed a workers' compensation claim. Another example is an employee that has testified against the employer in an unemployment hearing. And another example is an employee that has contacted OSHA because of a perceived unsafe work environment. So final thoughts on retaliation. First and foremost is employers need to refrain from that first instinct, to be trigger happy to get rid of a complaining or problem employee, because in many cases it is an employee that's complaining about something that maybe is not, does not have merit or is baseless, but employers can get themselves in trouble if they use that rationale to make a decision to retaliate or terminate an employee. The next bullet there says even if an employee's claim against you as an employer is meritless, the employee may have a bona fide retaliation claim against you if the employee is terminated. So I think employers, that's the last thing they want, to have a claim to retaliate against an employee and the claim is baseless, and yet the employer is slapped with a retaliation claim because they retaliated against the employer. And with respect to retaliation, employers need to be aware that they have the added burden of justifying their decisions or actions to show that the decision to discipline or terminate was for reasons other than retaliation. So it's a good rule of thumb to just try to put yourself in the shoes of a third party looking at this, and does your documentation support and justify termination for reasons other than retaliation? Can you show that? Can you prove that you terminated somebody for reasons other than retaliation? And lastly, employees may not be retaliated against for engaging in freedom of speech or political activity. So move on to the next section here, which is at-will employment. Which the question is, what is at-will employment and how does it benefit employer? Most employers are aware of this term and may or may not be certain of what exactly it means, but in the absence of an employment contract, so this means that an employer has not engaged in a contract with an employee, and if this is the case, then they're considered at-will employers. An employer is an at-will employer, which means they're free to terminate employees at their discretion with or without cause. That same freedom is given to employees in that they may terminate their own employment at any time at their own discretion. Now, preserving this right is important for employers because although it is inherent in any employment relationship where there is not an employment contract, employers may do things, perhaps unknowingly, to erode the at-will doctrine under which they have some protection. And with respect to at-will employment, it is in all states except for Montana currently. So let's talk just for a minute about some of the things that employers can do to get themselves in trouble as it relates to at-will employment. And this category here is implied contracts. An implied contract is an agreement that is unknowingly entered into by the employer. So essentially what this means is the employer has created a contractual relationship with the employer through something that they have said or done. It can be a statement, it can be a document in a handbook, anything that would that the employer might say or do that effectively makes a promise that was broken when the employee was terminated. In this situation, the courts can imply that there was in fact a contract, even though the employer had no intention of entering into a contract. A couple of examples of how this might happen. Progressive discipline policy that states employees will be terminated after a second written warning. Well, the implication here is that an employer may not terminate immediately or after only a verbal warning, for example. So you probably want to take a look at your progressive discipline policy to make sure that it has the flexibility and the latitude to offer warnings, whether they're verbal, written, but it doesn't restrict you to how you're going to issue those, whether it's one verbal warning, one written warning. You don't want to be too restrictive with your policies. Another example is a statement or policy that says employees will be treated fairly and will only be terminated for just cause. Again, the implication here is that an employer may not terminate for reasons other than just cause. And if you remember going back to the beginning, at-will employment means that an employer can terminate at will, with or without cause. So if you put a statement in a handbook that says you're only going to terminate for reasons of just cause, then you've effectively nullified your at-will employment status. Some final thoughts on at-will employment. Although an at-will employer has the right to terminate with or without cause, it is imperative that employers first consider whether their actions may be in violation of any federal or state discrimination laws. So again, yes, you can terminate at will, but you need to be very careful to make sure that you are not violating any laws, discrimination laws, retaliation laws, what have you, that employees might be protected under. Second bullet there is conduct a thorough review of your employee handbook and any other policies to determine if there may be language or statements that may convey a right or privilege that is unintended. Again, the employer might say, well, that's not what I intended, but if the employee looked at it, and a reasonable person would look at a statement or a policy that may convey a right, then the courts might look at that and say, well, although it was unintended, you created a contract. The last thing is review your handbook and new hire documents to ensure that at-will employment statements are embedded clearly and they're stated frequently throughout the documents. So although each employer, with the exception of Montana, has the at-will doctrine in place and it's inherent in the employment relationship outside of a contract, you want to make sure that employees understand that. You want to state it in the handbook. You want to state it in your new hire paperwork so employees clearly understand that it is at-will employment. Okay. The third section here relates to performance-related terminations. Now this category is, as you probably would imagine, the most fraught with potential liabilities for an employer. In the case of terminating for poor performance, having documentation such as disciplinary notices or performance evaluations is strongly recommended. Employers are aware of that, but in many cases they get to that point where they're ready to terminate somebody and they look back and they say, well, we don't really have any documentation. Well, what that means that in the absence of documentation, it may be harder to prove that an employee was not terminated for other reasons such as discrimination or retaliation. So if we go back to the beginning here, when we talked about the different employment categories and the various categories that employees are protected under, if you terminate without documentation, how successful might an employee be to bring a claim of discrimination against you for whatever it might be? Maybe it's for race, maybe it's for religion. If you don't have any documentation to show that it was for performance reasons. And this is why it's so important. One of the first questions that should be asked is an employee that's about to be terminated protected under any specific employment categories? And in some cases, it might be protected under more than one category. Another consideration as it relates to performance-related terminations is to determine whether an employee's poor performance, you got two words in there, sorry, whether an employee's poor performance may be due to a disability. Employers under the ADA are required to offer reasonable accommodation. We talked about that just a few moments ago. to an employee that's disabled in an effort to help the employee perform the essential functions of the job. Important, though, for employers to understand is the employer's role in determining whether an accommodation needs to be provided. An employer can't say to an employee, can't think or say that, well, I did not offer an accommodation because my employee never asked me for one. Well, if it's a situation where the employee was clearly disabled, the employer has an obligation to engage in what's called interactive dialogue with the employee to determine if an accommodation is necessary. And then, of course, it's important for the employer to document that dialogue, that conversation, to show that, in fact, an accommodation was offered. Or maybe it wasn't offered, but at least there was the due process, so to speak, of going through the exercise with the employee to determine if, in fact, a reasonable accommodation could be extended. More considerations related to performance-related terminations. Unless an employee does something as grounds for immediate termination, an employee should never be surprised that they are being terminated for performance-related reasons. Just a good rule of thumb is when you're about to sit down with an employee that you're going to terminate, unless it was for something grievous, which would require immediate grounds for immediate termination, the employee should not be surprised. They should be aware. They may not agree with it, but they should be aware at least that there were performance issues because you've had conversations with them and the performance-related issues have been documented. During the during the interview, and David's going to get into this in more detail, but you want to be brief and candid with employees as to the reason for their termination. And if the poor performance has been documented, there is no reason to be vague about the reasons why an employee is being terminated. And then finally, ask yourself as an employer, and ask yourself this question honestly, whether other employees in similar situations have been treated the same way. Employers are required to, especially as it relates to employees that are in protected categories, employers need to treat employees similarly. So, for example, in asking this question, an employer, could they honestly say that an employee in a protected category versus an employee that wasn't in a protected category, were they treated the same? Was a lesser punishment taken with an employee in a similar situation? So consistency is important as it relates to similar situations. And finally here, the last slide, I'm going to talk briefly about layoffs or position elimination related terminations. Now these are not as a general rule, not as precarious as terminating for performance. However, there's some things employers really need to understand as it relates to layoff decisions. And they need to base their decisions on criteria that are neutral or blind to an employee's age, race, national origin, religion, gender, disability. Those are the protected categories we just talked about. And when terminating, be careful of the unintended consequences of who you're going to terminate. For example, an employer that chooses to lay off some of the highest salary earners in the company may be unintentionally targeting the oldest employees of the company, resulting in age-based discrimination. So this is a situation where employers really need to step back and look at it and say, is the decision I'm making here, does it impact in a negative way any employer or employees that may be in protected categories? Now, it doesn't mean that you can't terminate or you can't lay off employees in that fall into those categories that might otherwise be protected, but you need to be able to show that your rationale was unbiased. And that's the final slide for the section that I've been covering. I just want to emphasize that as it relates to the guidance and help that is needed in order to understand these various laws, I mean, your human resource professionals can help you with this, can guide you, and I would just strongly recommend that before making any termination decision to contact your contact, at the PEO whether it's Century 2, Professional Staff Management, or ESG, and ask them and say, hey, am I doing something that I shouldn't be doing as far as terminating this employee? And what we'll do is walk you through it and ask some of these questions so we can look at it and say, is this a situation that perhaps we need to have better documentation, or the employee's in a protected category, or what have you. So these are important things to do before a termination event occurs. It's too late if you make that termination and then look back later and say, we may have a problem here. So that is all I have. I'm going to turn the rest of the time over to David, and he's going to give us some best practices and practical guidance.
Thank you, Mark. So for the remaining of this time, I'm just going to kind of go over some of the highlight of the things that you can really expect in a terminating an employee. Some terminations aren't always going to be the same. There's going to be a lot of situations where you'll have to treat them individually according to the actual circumstances. So prevention is the key. Getting a start so you don't have to reach that termination. Some of the things you can do is define the job expectations, goals, job descriptions, clearly defined handbook policies, employee evaluations and feedback, giving that along the way so you can improve performance as you go or your expectations as you go. You want to be sure to follow progressive discipline if that's what you have in your handbook, if that's what's described in there typically. That's a verbal, a written, a suspension, and then a termination. It doesn't have to be that type of scenario, but if you're following these guidelines, it does help you be consistent in your terminations. And then trying to get a documented signature for all the employees every time you have one of these discipline procedures. When an employee refuses to sign, just having someone acknowledge that the employee refused to sign and putting that in the file is just as helpful. Limiting the liability by being consistent. Anytime you change your practice or you do something different, you're going to be setting a precedent that you would change your consistency of what you'll have to do in the future. So be mindful of when you're changing your practices of what's going to set up for the future. Be private as much as possible. Be direct. Keep it performance related. Train your managers. If your managers are doing your terminations, making sure they have all the proper information and that they're properly using the right words in order to have a successful termination. And then have a case review before termination, a final sign-off. What this does, as Mark mentioned earlier, gives you a chance to make sure that this termination isn't different than maybe another termination. Prime example would be a safety concern. If you had a terminated employee for leaving a banana peel on the floor, and that was a safety concern, immediately terminated, if you go back and review, you might find that another manager had given several warnings for leaving a banana peel on the floor. Just something to keep consistent and making sure that you're not setting any new precedent. Don't summarily discharge. Suspend someone and send them home. Given a chance to make sure that you're able to review the reasons for the termination, making sure that it is sound and consistent with what you've practiced in the past. Plan in advance what you say when you do have a termination. Sometimes it's helpful to have a script, writing it down so you're following something very consistent of what you want to say and help keep you on track during this determination. Keep it short. Be very specific to what the termination is. Try not to go off line and talking about things that aren't really related to the actual termination. Protect your company assets. Anytime you have passwords the employee has in their possession, keys, certain files, credit cards, and keep it civil. Picking the right place. Is the place private enough, or in some cases you may want something a little more public? Having the right place where you're having the termination can set the right tone and make the termination much more agreeable for the employee. Settle any pre-arrangements as far as any loans or advances that might be held out. If possible, you can hold the final check in any other property for this return of the property. Most states don't allow this. But another example to get around this or to help with that is have them come pick up their final check and bring in their stuff with you. That'll at least give you an opportunity to allow them to bring that property back to you on their last date in order to pick up their last check. You may want to have security as a backup. It's recommended to have a witness, another manager, someone else there can actually be a witness to the termination and the things that were being said and discussed. And the employee should see it coming. So in a good situation, it's not going to come as a surprise. However, if there is a surprise, that means there might be some management issues that we could improve on in order so that it's not a surprise when an employee sees a termination. Notify your workforce. When you're dealing with terminations at the end of a week, it leaves a lot of time for employees to speculate and talk. So having that notification out in front of it and letting them know what's happened in the termination or employee is no longer with you. Consider the timing of the termination. This would be something if you're terming someone and haven't had a chance to review the full file, that employee may have already been in some sort of engaged in some sort of protective activity, or they might have already filed a complaint that would protect them from any type of retaliation, as Mark had talked about earlier. And lastly, some situations might warrant a separation agreement and a release statement. Anything to reduce your liability after releasing the employee, that they might come back and file a suit of any type to increase your liability and cost. Some other ways you can consider to help reduce liability, outplacement services. If you have a service that gets the employee back into the workforce more readily, it'll help reduce the amount of cost to you. Releases, release agreements, a severance pay, something in lieu of signing that agreement to help reduce the amount of retaliation or claims against you. EPLI insurance. In the event you do have claims against you, they're covered under employer practices and liabilities and discriminations. This insurance will help you with your reduce the liability and compensation that you have to give back to in the event you are found guilty of discriminatory practices. And then a mediation. Involving a mediation in some states or under some circumstances also reduces the liability after the fact. A couple things about WARN. It doesn't apply to all employees, but the WARN Act, known as the Worker Adjustment and Retraining Notification, it does require employers to provide all affected non-union employees, representatives of unionized employees, and designated state and local government officials with at least 60 calendar days, whether when it's regarding a plant closing or a mass layoff occurring at a single site. WARN generally applies only to private employers. A public employer that operates a commercial enterprise also may be covered. However, to be potentially subject to the WARN, you must have 100 or more full-time employees or 100 or more employees who, in the aggregate, work at least 4,000 hours per week. So if you had a bunch of part-time employees that would make up that number, it still would be considered underneath the WARN Act. Just a couple small definitions. A plant closing, when there's 50 or more employment losses for full-time employees. Also, if one or more operating units within that facility is closing, could also be covered underneath what's considered a plant closing. A mass layoff, a little bit different, occurs if there's employment losses for a minimum of 50 full-time employees and at least 33% of the full-time employees at a single site of employment, or if 500 or more full-time employees experience employment losses within the applicable period. So if you're a larger employer covered under the WARN, a couple of things that would you need to know when underneath the WARN Act. So the WARN Act, layoffs, downsizing. Right? So some of the things when you're downsizing your workforce that you would need to be aware of. You'd want to review any company bulletins and anything that's been posted about the downsizing and making sure it doesn't have anything related to the protected classes that Mark had talked about. You want to develop a non-discriminatory criteria of how we're deciding where the layoffs, where the downsizing is going to occur. And you can also use non-discriminatory criteria in any previous layoffs that you may have had. Workforce reduction goals should be stated in numbers of employees to be reduced and not necessarily how much dollars you're saving. You should review any performance rating systems or other neutral criteria for possible adverse impact discrimination. Basic example of adverse impact discrimination or certain tests that you might provide employees that when taken and the results are come in, you might find that certain protected classes are actually scored differently based on that test, and so it would be a adverse impact discrimination by applying something that might discriminate against a protected class. Recent college graduates or other categories of younger employees should also be included in these reduction decisions. That will keep you from any, help you reduce any age discrimination claims. Do not disfavor higher paid employees. Generally speaking, the longer the employee's tenure there, they're going to be higher paid, and generally that means they're going to be the older workforce, so not necessarily relating it to the salaries could help you reduce any age-related. Ensure that the reduction in force is consistent with any company affirmative action program. So if that is, you are part of providing affirmative action plans, then you'd want to make sure you're consistent with that. 2 or more management officials should be involved at every level of decision making when you're discussing the workforce reduction and during every meeting with the affected employees. And whenever possible, that management group, that decision making should include protected classifications as well. Older individuals, minorities, females. This here will keep the oversight committee balanced and help you when it comes to decisions and reducing possibilities of discrimination. Ensure if you're offering early buyouts and early retirement incentives, and in fact they are voluntary and not non-discriminatory for any of your classes. And then after the reduction decisions are made, document the individual decisions based on the selection criteria. That way you can develop an EEO profile of the likely affected employees for disparate impact analysis. Disparate impact analysis would be unintentional impact. If one of your criteria for reducing your workforce would be we're going to keep all of our family and friends and referrals that came through the company because we know them the best. Well, if all of your family and friends and referrals are actually tall basketball type players, you might have an impact against your shorter workforce. I'm not sure short is a discriminatory practice, but the idea is the same. You didn't really intend to eliminate all the shorter people in your workforce, but indeed you might have. Employees selected for termination should be the extent possible. You might want to consider them for transferring them or demoting them or on any type of uniformly criteria that you can objectively put across the board for making any types of other decisions instead of the termination. One of the first questions that will come up when it comes to a downsizing is, well, how did I get selected? Why me? And in every case, adversely affected employees, supervisors, and the decision makers should be prepared to explain, well, this is how we've come to our decision, this is how it's been laid out, and this is how we've been able to uniformly apply that for all of our decisions in the downsizing. Communicate. So identify a communications czar, at least someone that's coordinating the communications with the employees, the union officials, the elected officials, making sure that you're having that common relayed message to everyone. Consider the effects on the remaining employees. So now that you have downsized and who's left, how does that impact the morale of your company? How does that impact what's going on after the fact in your production? So making sure you're having that information and plan after the downsizing. So during the separation, a successful separation, prepare the materials, explain the rationale, and prepare all the severance information in writing. Prepare the message. Again, maybe this is a script. Have this down so you're staying to the script and be able to convey the proper message to the employee and keeping it short and to the point. Arrange the next steps. Schedule meetings with your organization's HR and outplacement professionals, reviewing what should be done with the departing employee's personal belongings, and maybe specify when the employees should leave the organization. We'll talk about that a little bit more. Prepare yourself emotionally. Don't assume personal responsibility for the termination. Remember, it is a business decision, but it's important to acknowledge your anxiety about your approach, talk with it about your human resource and other outplaced professionals. Anticipate employee reactions. So typically 5 reactions to a termination: anticipation, disbelief, escape, euphoria, or violence. So by acknowledging the various reactions that you might experience, you will ensure that no matter what your reaction is, you'll be best prepared to handle it. When conducting either voluntary or involuntary workforce reduction, it's advised to make the first staff cuts deep enough so that you don't have to continually go back to the well to have to make more and more cuts. So the idea of the Chinese water torture, smaller cuts, is not very helpful, and the goal is to actually cause the minimal disruption and trauma to the organization and its people. So minimizing the amount of times you actually have to go through a layoff is the preferred method. So during the termination interview, so begin the meeting by stating the reason for the meeting. Let the employee know the decision, the reason for decision, how you came to that decision. Understand that the employee needed to know that it's a final decision. It's not an opportunity for have a discussion further about it and to try and change your mind. But the employee will be, obviously, with the emotional reaction that we talked about earlier, you may still want to give them a certain amount of time to vent, disagree, and listen patiently when that does happen. Explain the employment rights, right? Whether or not you'll protest the claim for unemployment, and these days actually what the actual separation information provided to the unemployment office will be, what their continuation of benefits, how that impacts the employee, vacation pay, severance pay, and then how you will handle references when they come back in when the employee is seeking additional work. This can be an embarrassing time for the departing employee, so you may want to offer a different time when they can come back and actually collect their belongings. Sometimes an early morning appointment or after hours is a little bit easier. However, there may be some times where goodbyes. You might want to offer a certain amount of time for them to say goodbye to their coworkers. But you want to keep it as a minimal disruption to the workforce. If you're concerned about the employee becoming agitated, take the following steps to protect yourself. I myself am not a physically imposing person, but I'm fast. So maybe putting myself closer to the door so I'm first one out the door might be a better opportunity for me. In the event that the employee might be almost as fast as I am, even putting more barriers. Maybe I'm still closest to the door, but there's a desk and a chair in between. Anything that I can give myself to keep myself safe. You may also want to have a third party at the meeting, someone who can restrain an angry employee. That would be a good choice. And during the meeting, making sure you are protecting any of your company information, files, folders, any property that you don't want leaving with the employee. And just a couple last do's and don'ts. We talked about do lay off or terminate on a weekday other than the Friday. I mentioned that earlier, but the Friday and the weekend allows a lot of time for inactivity and a chance for the employee to really sit and not be productive, whereas early in the week they can go in, file for unemployment. They can also start looking for their jobs in their job search early, and it'll keep them active versus inactivity time, which can be more damaging to the individual psyche. Do put in writing everything you thought the terminated employee will find helpful. Although you will cover the information during the meeting, a lot of times the employee is hearing one thing in the termination and they're not able to actually hear all the important points that you were trying to give to them during the meeting. So by providing them that something after the meeting to take with them, gives them a reminder, and it'll keep them on track afterwards of some of the helpful suggestions that you provided them. A couple of the don'ts. Don't belittle or demean the departing employee. Use gaps in expectations and other objective criteria to keep the conversation on a professional level. Remember, it's not a personal. It's not that typically the person's not a bad person. It's really related to what the job is for your company. And then don't use attitude in your conversation. You wouldn't have hired the person with an attitude, so probably more than likely that attitude developed while on the job. And of course, in any termination, most termination situations, there is blame to be on both sides. So just some of the information on determinations, and I will hand this back over to Kim.
Thanks, David and Mark. Appreciate your presentation and some really helpful advice on what is often a really challenging situation that all of us have experienced in terms of separating employees from the company. I don't think I see any questions. I think for the sake of time at this point, I'd like to just offer anyone that's on, if you have specific questions, of course, your HR team member at your designated PEO is more than happy to help specifically address any questions that you may have. And of course, they are always a resource as you're contemplating making a termination decision. Many of our HR team members even go out on site with a client in more challenging terminations that happen just to help facilitate it and make that be a smooth process. So be sure that you're taking full advantage of your HR team members in those kinds of situations. I'd like to invite everyone. Our next webinar will be on March the 17th at 2 Central. This is going to be a really great webinar. I think we've got a guest speaker. His name is Scott Augenbaum. Scott's worked with the FBI, and he actually consults with employers, educating them about cybersecurity and helping employers take proactive steps to minimize cyber attacks and minimize potential fraud that may happen through their IT practices and their security practices that they have in place. This will be a very practical session, a 1-hour session, where he'll give very specific advice and talk about some very specific examples of how employers have been faced with these really real-life situations and things that we can do to help prevent that happening in our businesses. So I hope that you will mark that on your calendar and join us for that webinar. Additionally, on the 19th of April, we will be talking about what other employers do. And in that session, we'll be talking about not only from a national perspective, but from our own PEO perspective with small business owners, what they do in terms of how many vacation days are offered, what do employers pay towards medical coverage, what types of benefit plans do employers offer, and other types of HR practices that are in place that will help give you a good perspective of what your competition around you may be doing as you evaluate the practices that you have in place at your company. So again, we appreciate your time today, and following the presentation, the webinar, the slides will be emailed out to all the participants. Thanks again.